everyone, welcome back to The Student Lawyer. Today I'm going to be talking to you about the recent Uber v Aslam decision in the Supreme Court and any implications that this could have in the future. So for those of you who aren't aware with the Uber platform, the way that the business model works is that individuals can book trips with an Uber driver and Uber will then take a commission for these trips. Uber says that their drivers are only working whilst on these trips. So the claimants were drivers for Uber and they wanted to be classed as workers instead of independent contractors so that they could be entitled to national minimum wage, to sick pay and holiday leave, and also so that they could have protection from whistleblowing claims. Some background facts of the case is that Uber drivers had to undergo an induction before they could be classed as drivers. They received a welcome pack which talked about how if they received unfavourable comments or feedback from clients, then they could be removed from the platform. Another important factor in the case was that drivers had to give personal service to Uber. This meant that their access to their app was only for them. They could not substitute it with somebody else. However, there was no exclusivity clause, so drivers could work for competitors like Bolt or Free Now, and this became important when it came to court because the judges struggled with the idea that individuals could be working for Uber at the same time as working for Bolt within one shift. Something else that was considered important was that Uber drivers could accept or refuse trips whenever they wanted. However, they had to accept 80% of trips, otherwise they'd be logged off the app. And they also had to accept any trips within 10 seconds, otherwise the trip would be given to another driver. So when the claim came to the Employment Tribunal, the tribunal found that the employees were workers within this definition in section 230B of the Employment Regulations Act. And this was because they found that the reality of the situation didn't correspond with what Uber had written in their contracts, meaning that individuals were entitled to holiday pay and sick pay as workers. Uber then appealed this and took the appeal to the Employment Appeals Tribunal, who still found in favour of the individuals and said that they were workers. Uber therefore went to the Court of Appeal, who again upheld the decision, and then Uber then took this to the Supreme Court, which, as the highest court in the UK, Uber can't appeal any higher than the decision found at the Supreme Court. The Supreme Court unanimously dismissed Uber's appeal and found that the individuals were workers within the definition. So we're going to now look at some of the reasoning behind the Supreme Court's decision. So the reasoning of the Supreme Court was based on the control that Uber exercised over its drivers. So when individuals used the Uber app, they'd put in all of their details, but drivers wouldn't see most of this. They'd only see the first name, they wouldn't see the last name, they wouldn't see the destination the individual wanted to go to. And this was to prevent drivers from picking and choosing the areas they wanted to go to, meaning that Uber held all of the information and the drivers only acquired it once they accepted the trip. Prices were already preset by Uber as well, so drivers have no say in the price, although they can ask for a little bit extra from an individual, but this is to be agreed between them. And the money never goes straight to the individual, it goes to Uber first, and they give it to the driver in a form of invoice. So when the case reports come out, this will be a really interesting one to read because of the way that it could reorder the gig economy, and also because Uber has such a big presence in the UK and around the world. Uber will also be liable for thousands of pounds of compensation for the claimants, but also for other drivers, and this can be backdated. So now post-Uber, the biggest impact won't even be employment law related, but the fact that with the previous model that Uber were operating as the intermediary between driver and individual, there was no VAT payable on the service, but now that the agreement is between Uber and the individual, there will be VAT payable, and this can be back paid as well. So there's an estimate of about, I think, 1.5 billion that Uber now owe in tax, plus interest and penalties. So I want to be in their position. So now the wider impact is that the gig economy was already under quite a lot of pressure with lots of calls for new legislation in this area. And as a result of the Uber decision, the European Commission are scheduled to meet with different workers and discuss new legislation in the future. This will also have wider implications for business models which are similar to Uber, because now drivers will be entitled to national minimum wage, to holiday pay and so on, instead of just the commission that they're currently getting. This could also impact other industries. So for example, Amazon use a flex gig worker program, and this could be impacted as well by the decision by the Supreme Court. Okay, so now a competition law aspect, because it is my favourite area of law. Uber recently acquired AutoCab in an attempt to branch out its services outside of cities it's not currently operating in. And this is bound to affect AutoCab drivers, who will now probably be workers too. And this in itself is its own issue because the CMA are currently investigating this acquisition, and they have until March 26th in order to clear it or to ask for more information. So this in itself could be stopped yet. So that's a brief insight into the Uber v Aslam case. All of the reports from the appellate courts should be online, and I think the Supreme Court one should be posted pretty soon. So thank you for watching. I hope you enjoyed the video.